The proposed copyright amendment bill, which will amend the current Copyright Act, is raising serious concerns in the creative sector. For instance, musicians are concerned that the new bill, in reference to the case of musical works, excludes authors and composers from the automatic right to receive royalties for the broadcast of their music by broadcasters. Another concern is that films funded by the National Film and Video Foundation and the Industrial Development Corporation, these producers won't necessarily have any copyright ownership in such films. Well, this has led to the formation of the Copyright Alliance, which is an organized collective of stakeholders in the creative sector with a keen invested interest in the developments in the South African copyright industries and legislative framework. Advocate Joe Baloyi is a member of the Alliance and joins us now to tell us more about their concerns. A very good morning to you, Joe.
Good morning. Good morning. Thanks.
Quickly give us a background in what it is that you do.
Okay. Well, I'm a copyright consultant and an entertainment law consultant, also an academic working at UNISA as a senior lecturer. But I've also endorsed this initiative of the Copyright Alliance.
Yes.
Because I really believe that it's very necessary to highlight the problems that really arise from the proposed amendments to the Copyright Act. This is actually something very big, very huge, that really needs national attention, and people should really understand what is actually happening here.
And so maybe you should highlight those problems that you see currently existing and just take us through them.
Okay. I mean, I think in the outset, I'd like to say that we don't want to raise this alarmist, position that everything is wrong with the proposed amendments. I think that the amendments themselves are long overdue because, our Copyright Act was enacted in 1978 in the pre-digital age. And so it's important that, we develop it to keep it in par with developments internationally. However, the problems that arise here, go to the very core of the philosophical premise for the protection of intellectual property works, or copyright works in particular, which if I were to just try and explain what that is, and it's an internationally accepted premise, or what I would call a conceptual framework for the protection of copyright works, which is based on the so-called incentive theory, which says that society, through legislation, must give to the creators of creative works and limited duration exclusive right. So the exclusive right is for a limited period, but it is an exclusive right, and that is important to understand, over their works, in terms of them being able to exploit those works, use those works, or authorize another person to do that. So those rights are in the nature of exclusive rights. And because of that, it's important that they should be given unrestricted right to actually use those works or authorize others to use the works. However, this is for a limited duration, as I said. At the end of a certain period, the works are then released to the public domain, and everybody can actually use them in the promotion of the arts, and in the dissemination of information and all that. So it's for a limited period, but they are rights in the nature of exclusive rights. But however, even within the system itself, the system acknowledges that even during that period where the authors or the copyright owners have exclusive rights, there should be a certain latitude in terms of allowing people, others, to actually, make use of those works for fair purposes or in fair dealing. So you have that actually incorporated into the system itself, and that's what we call the fair dealing provision. In international law, it is based on what is called the three-step test. What it means is that it can only be allowed in certain limited special cases which do not conflict with the normal exploitation of the works by the rights holders and do not prejudice the legitimate interests of the rights holders. But what we're seeing here is something else, because it's actually encroaching into that. It is really, what you're seeing is what I would call the author problem versus user victim syndrome. And what I mean by that is it's a situation where the author is almost seen as being the problem. The copyright owner is being seen as a problem for users to be able to make use of those works that were created by the authors. And almost what is happening is saying a free-for-all, whereby users should be able to use those works without any restriction at all. And that is where the problem arises.
And how does that change the game, specifically where broadcasters are concerned? Because I think often you'll find that the broadcasters will then obtain the rights of the work, leaving sort of the artist out in the cold.
Yeah, I think that's important. But again, I also want to highlight the fact that when you talk about copyright, it doesn't only protect, creators of musical works and literary works and things like those, but it also protects broadcasters. So there is also copyright in the broadcast itself. This broadcast that is happening here, the SABC owns copyright in the broadcast itself. So, but back to the question of the authors, because authors have an exclusive rights, they should be able to benefit from the economic exploitation of their works. And so when music is being played, like I'm seeing music's going to be played, the creators, the owners of the copyright in those compositions should be compensated, and that has never been a problem. I mean, the SABC has been paying royalties for composers and copyright owners all this time through SAMRO, through Capasso, through other industry organizations. That has never been a problem, but what is being proposed now is problematic in the sense that there is now a provision that says that works that are funded by the state, and you know the SABC is an organ of the state. I mean, is an organ of the state in a sense. So works, if a musician were to be commissioned by the SABC to create works, and those works are broadcast, and traditionally, as I've said, they would earn royalties through SAMRO and other organizations.
I do get it. Unfortunately, we're going to have to leave it there. We are out of time. I wish we had more time for this discussion. Advocate Joe Baloyi is a member of the Copyright Alliance. All right, it is time for us to take a quick break. We'll be